So dear students and colleagues, welcome to the last and the concluding sessions on emergent issues in international commercial arbitration, jointly organized by the Singapore International Arbitration Center and the Center for Alternative Dispute Resolution, OP Jindal University. So today the topic is contemporary issues in investment arbitration. As you know that India has traditionally been somewhat reticent about investment arbitration, but since 90s we changed our stance, and then we had like 85 PITs. Then suddenly we changed our mind again. We had the White Industries Award, which went against us, and we lost confidence and we started scrapping our PITs. But just because you scrap your PITs does not mean that the liabilities under them go away. So you still have a large number of investment claims that is made against India. The problem is now there does not seem to be any viable method of enforcing them, because we are not party to ICSID. They are sometimes not treated as commercial arbitration awards, and there does not seem to be ways. The investment law itself is undergoing major changes because the traditional portal that it existed was for investor protection. But the form that we have now moved into seems to be more of a policy centric, and it has the diversity. It takes into account the diversity of opinion and the diversity of circumstances that exist in the world today. So to talk about all this, today we have with us Ms. Sweta Viduri, who is the South Asia head of the Singapore International Arbitration Center. Sweta is enrolled as an advocate in 2007. Prior to joining the SIAC, she was an advocate with a leading Delhi law firm that specialized in commercial arbitration and commercial litigation. So Sweta has participated even before SIAC. She has participated in a large number of cases that has set up the law regarding that affects the global companies, that affects the global commerce today. So that's enough of an introduction, I think. So Sweta, the floor is all yours. Thank you.
Thank you, Subrajyoti, and thank you for bringing together these lecture series. I, of course, have a very difficult task ahead of me, given that I'm the last one in the series. But I'll try and do my best, to be able to sort of address the issues that we're trying to identify in investment treaty arbitrations. So I'm just going to run a presentation to give a context and background to the issues that I've sort of identified. While the topic is contemporary issues in investment arbitration, I think by no means these are new issues. These are issues that we've been discussing and talking about for a while now. We also have UNCITRAL Working Group 3, which has been identifying reforms, and the ways in which some of these issues can be addressed, and which are, of course, been hugely debated and talked about recently. So just give you a context, for maybe some of the beginners of investment treaty arbitration, to start with some facts and statistics. Okay. So let's look at where do we stand in terms of the number of investment agreements that have been signed between 1980 to 2020. If you look at the trend, it's really in the 90s that the trend picked up for signing of investment treaties, and particularly in 1996. In fact, even India became party and signed majority of bilateral investment treaties in the 90s. While you see there's been a bit of a decline in 2000s and of recent years, in fact, from India's context as well, we've been discussing a lot more of investment treaty arbitrations post 2012 and 10, particularly after the White Industries case. So while the treaties existed long before that, but the impact and the effect of these treaties, what does it mean for India? I think we began to take that notice more particularly after 2010. And of course, in 2020, we're discussing whether there's been a backlash. What is it that we need to do? We need to identify the issues, that are currently existing in the system, and how can we fix. So I think if I were to term the phase, from now on, from 2020 to, I think, next, if I can safely say, to about 10 years, is really a trial and error, where we will identify, we will try and, introduce newer principles and concepts, and newer ideas in the investment treaties and see how they respond, for us to truly take a new shape of the investment treaty regime in India itself. Next are the annual number of cases. So while we saw at 90s majority of the treaties that were signed, the effect of these treaties really came in from 2010 onwards. And look at the trend, if you look at the numbers around 2012 to 2018, there's been an increase in the total number of ISTS cases. And of course, the popular repository of the ISTS cases remains to be ICSID, and which is what you will see in the green and orange coloration of what have been the ICSID cases and the non-ICSID cases. Just before I move on to the next slide, India, as you know, is not a signatory to ICSID. India has had its own reservations for not signing ICSID. So currently, most of the investment treaty arbitrations involving India are being conducted under the UNCITRAL rules. So there's really no institutional facility that's available for India under the current treaties. And it remains to be seen whether India will at some point reconsider its stance, to become a signatory to ICSID. And I think some of the reservations that Subrajyoti also mentioned about enforcement, have tie into what happens to awards in an ICSID case. Do the states get a chance to be able to relook at the mechanism itself, to relook at the awards, which could have been one of the reasons why India has chosen not to be a signatory to ICSID. Then drawing to the basic framework of investment treaties. Of course, in a bilateral investment treaty, the parties are usually an investor and a sovereign state. The legal basis of an investment arbitration is the bilateral investment treaty itself. While there are different kinds of investment treaties, there are also multilateral treaties. You also see free trade agreements, etc. But the focus is largely, from India's perspective at least, is on bilateral investment treaties. The recent cases, the recent discussions of how we've been sort of shaping investment arbitrations really arise out of the bilateral investment treaties. Now, how do these investment treaties structure? How do they work? Where do investors derive their right to file arbitrations against the state? So really, the investment treaties work by providing a framework where there are two states. Essentially, if I give you an example of India and the UK, both come together they promise each other and undertake the obligation to treat the investors of the respective state, in a certain manner, which generally provides for a charter of investor rights, which includes that they will not expropriate, without any lawful compensation. They will treat them fairly and equitably. And there is, of course, a mechanism that is provided in these investment treaties that in case there is a dispute, where the state has either failed to provide or live up to these obligations, or the investor feels there's a breach of the rights that have been granted under these treaties, then there is a mechanism, which is the arbitration that is provided under these treaties, which the investor can utilize, to pursue, to reinforce their rights under the treaties. So, when an investor invests in a state, and if we go back and look at the history of investment treaties, it really worked on how there was a developed country and a developing country. And when the money started to flow from the developed countries into the developing countries, the investors feared, that the regime that the developing countries were following may be unstable because they were still undergoing changes in their system. The laws were being developed, and the governments being changed. So there was a significant amount of uncertainty and the risk that was involved. In fact, if you look at some of the prominent jurisprudence in investment treaty arbitration, that comes from cases relating to South American, Latin American countries, and where also there's this great risk about how the governments functioned, and the investors feared that their monies might get locked in and they will not be able to get their returns. And so gearing up for these circumstances is why these countries entered into treaties where the developed and the developing countries promised each other to be able to take care of the investments that have been made by the investors of the other country. So it basically protects the investor against the sovereign risk. Then it protects against the interference that may arise by way of the action of the legislature, executive, and judiciary. So any arm of the state itself. Yeah, like I said, that there are rights that are granted to the investors in an investment treaty, which by way of arbitration an investor can assert and can get their claim against the states. The complexity in investment treaty arbitrations, and why is it so nuanced? If you look at the field of investment arbitration, of course, we've had arbitrations from long ago, even in India before the 96 Act, there was the 1940 Act, even before there's a system of arbitration that existed. But investment treaty arbitration is still relatively a newer concept in that sense. It becomes more complicated because of the interplay of so many different laws. So, of course, the primary applicable law in an investment treaty arbitration is the public international law, the underlying treaty on the basis of which a claim is made. There are laws of treaties and the law of state responsibility. Then, of course, you look at the domestic law and understand and try and understand how those interplay. There are domestic laws and regulations that are also interplay within this whole spectrum of laws that are defined and come together in terms of determining the rights and obligations of the parties. So that's one aspect. Now, going back to see a bigger picture, if we zoom out a little bit and look at where do the Asian states stand, where do the Asian investors stand in investment treaty arbitrations? So if you can look on the screen right now, and this basically says that how many investment treaty arbitrations have been against Asian states. So India has been leading in terms of majority and maximum number of investment treaty arbitrations against itself, followed by Pakistan, and then the other countries such as Vietnam and Korea. Notably, there has been no investment treaty arbitration against Singapore as yet. So, I think looking at these numbers in a way signify the importance. I think most of you who are listening as students as well, that how for India going forward, it's going to become even more important to understand how investment treaty arbitrations functions, how from the policy perspective you can contribute in developing, in developing this field of law, and how you will see the jurisprudence in the field itself will evolve over the next few years. So India really stands at the center at the moment, and not just from Asia's perspective, but really I think the world is watching very closely at how India is responding, and responding to understand how their response should be also. So in India, really trailblazing in a sense in terms of responding and relooking at the regime of investment treaty arbitrations. Then an interesting debate has recently been about that. Of course, India has relooked at its investment treaties, but are we looking at the Indian investors investing abroad? We are of course concerned about protecting the interest of the state. We're talking about protecting the sovereign rights and the balance of that with investors' interest. But what happens, when Indian investors, of course, we are no longer only a capital importing state. We are also exporting capital, which means a lot of money is being invested by Indian investors abroad. And this chart is really, the figures speak for itself, that there have been 9 Indian investors who have filed investment treaty arbitrations against foreign states. So I think when we're re-looking at the regime, at certain point, we also need to be able to balance the two, the foreign investors with the Indian investors' rights. Then these are really examples of what kind of conduct gets challenged in investment treaty arbitrations. And this is really about from cases from 2010 to 2019. And of course, if we look at even India's cases from, Dabhol until recently, what are the kind of cases that you see, the kind of state conduct, India's conduct that has been challenged? So one of the most common cases, if you read any jurisprudence in investment treaty arbitration, are really the termination of contracts, or taking away of the concessions that were granted by the states in the first place. And then you see a lot of cases of direct and indirect expropriation of investments. There have been also cases where sovereign states have introduced legislations to combat their financial crisis. For example, the Argentine cases, when the Argentine government had introduced certain laws and to combat the financial crisis that it was going through. And there's this whole spree of cases that were filed against Argentina. We've also seen changes to the domestic regulatory framework. For example, when an investor come and invest in your country, there are certain exemptions that were granted or certain tax benefits that were granted. And after the investment has been made and the investor has been running its business in the state, then the state goes on to change its laws. So of course, there have also been investment treaty arbitrations arising out of such conduct. Some cases where the investors have felt that they have been investigated, or there have been criminal cases against them which have affected their investment itself. So there are really slew of conduct that gets covered within the ambit of the conduct which can be challenged under investment treaty arbitration. In fact, recently, we were in discussion about what sort of cases we might see from COVID-19 regulations that the states have been undertaking. We've of course been discussing about the straight line measures that the states have taken, such as the lockdowns, etc. Whether those would get challenged at all, because of course the business has been affected severely. People's employments have gotten affected. So at large level, you've seen a huge impact on the investments, on the businesses, the foreign investments, that have been invested into different countries. At some level, they're also weighing, what the state's conduct has been vis-a-vis their own domestic businesses versus the foreign businesses. Has there been any differential treatment in the way the states have been treating the two? So, these are, of course, with times to come, we'll be able to see what kind of cases will arise out of the COVID-19 measures that the states have taken. So, but in short, there is really no end. It's not defined in certain terms. Various kinds of conduct will fall under investment treaty, which can be challenged. But broadly, it has to fall within the violation of the rights that are granted under the treaty. Now, whether or not that conduct violates a certain guarantee that has been made under the treaty is really the test, that one sees in these investment treaty arbitrations. This is really, again, a broad overview of India's journey in investment treaty arbitrations. And if you look at from 2000 to 2020, it hasn't been very long, but we've still seen a very prominent development in the way how things have responded and moved so quickly. Particularly after the White Industries case, and I think very few may know of that. White Industries is not the first case against India. It was really a number of arbitrations, that arose out of Dabhol in 2004, and those were eventually settled. And that also is significant, to understand what would the importance of these negotiations between the investor and the states would be going forward. What would the role of mediation would be in investment treaty arbitrations, in terms of the optics of where the state want to position itself, on a global front. It doesn't want to be looked at as a state whose conduct has been challenged a lot, or a state which has majority of investment treaty arbitrations against itself. It also, so from the policy standpoint, India will have to look at the history, the conduct, the present, its position before it charts out the future for itself. We are currently, of course, in the phase where we all have been discussing and debating the Brazil BIT. The model BIT was set into place, but then there were some modifications that were made to it. We did have, some take of the model BIT. Some have questioned, of course, with, whether or not the real test would be if India gets into a new treaty negotiation based on the new model BIT with a developed country. I think where there is a little bit of balance of the power, and to see what really is being the uptake, and that's going to be the test of the new model BIT. Then moving on, from where we've seen in terms of the number of cases, the complications in those cases itself are really the issues, that I wish to identify today. By no means these issues are exhaustive. By no means, the solutions that we may discuss are exhaustive. Of course, I think at some level, the center to the discussion on issues in investor arbitration and the reform are really undertaking it with the UNCITRAL working committee, which actually now going to be seating in another session from tomorrow. So it's really topical at this point to go and weigh in what the reforms are going to get suggested, and how that will shape the future of investment treaty arbitration, not just in India, but across the world. So I'm just going to close the slide and really discuss each of these issues. So the first issue that had been highlighted, and also something that's been in center of investment treaty arbitration, and if I were to give my own experience of when I began to work in investment treaty arbitrations, and starting from a simple point, where you have a state conduct by which an investor has been affected, and you start to evaluate under which head, would you want to challenge that conduct amongst the various rights that are granted under the treaty, starting with the fair and equitable treatment, right against expropriation, the full security. So when you look at also the jurisprudence in these cases and what do these legal protections mean, there is empty number of cases which can go both ways, and which really brings to the point of consistency in investment treaty arbitrations. Fortunately, if you compare commercial arbitration with investment treaty arbitrations, you do have a lot more public awards available, which are easily accessible, without even any payment of fee. So there's a huge amount of jurisprudence that is available for us to read, to even understand how the arbitral tribunals have interpreted, as simple as a concept of fair and equitable treatment. What would get covered within fair and equitable treatment? What would get covered within an obligation such as full protection and security? Does it mean only the physical security of the investment, or does it mean even legal protection? So these contours of the rights have been decided over a period of time differently by different individuals who sat as an arbitrator. So there is a significant amount of inconsistency in investment treaty arbitration, and that arises out of a number of factors. One, of course, is really arising from broad legal concepts. The definition of meaning of, like I said, fair and equitable treatment. What is the implication under the customary international law? Under different heads, And that is also a bit of a concern, and I think at some level, this is an issue that is being addressed, and everyone's figuring out a way of how do you streamline the jurisprudence to have more consistency. So if the law hasn't changed and there are similar facts, why are similar facts applied so differently in different cases? And of course, there have also been cases where you've seen different arbitrators adjudicating upon similar facts, and two different arbitrators have ruled on it differently, given everything else, all the other variables were same in the case. Another factor that has led to some sort of inconsistency in investment arbitration are also parallel proceedings. Because if you look at how investment treaties are structured, when investors decide to invest in another state, they also look at the structuring of their investment, which means, for example, if a country, maybe an English company wants to invest into India, assuming there is no treaty between UK and India, how would it structure its investment so that investment gets protected? And it will, via its subsidiaries, maybe structured in a different way, where the intermediary company is in a state where there is actually a treaty between India. For example, you see a lot of investments coming out of Mauritius. So these sort of structuring meant that at different levels, each of the intermediary had its own rights and protections under their respective investment treaties. So assuming a holding company from X country, which did not have an investment treaty, invested into India via 4 tiers. Yeah. So holding company then had its own subsidiary, which had its own subsidiary, and down the line 4. So you technically ended up having 4 investors, which had its own 4 respective rights. So when India's conduct affected the investment, then each of the investors at that level could assert their own right. There has been some debate in terms of, where you have such parallel proceedings, and the investors would of course assert that under their own treaty, there are different rights that are available at their own tier level. A good example, and which of course is available in public domain, was when Vodafone had sued India, had started investment treaty arbitrations against India in respect to the retrospective amendments. The first line of arbitrations were filed by the VIHPV, and then there's another proceeding that were commenced by the UK company, the UK holding company, in respect of the identical facts. Yeah. So, but of course, if you look at the judgment of the Delhi High Court, the argument had been that the 2 different arbitrations have been under different treaties, and there were different rights available under the treaty in terms of what the import and the exceptions that were given under the treaty, and the investor was not trying to double its game by getting benefit, or to have contradictory awards. And of course, there's some level discussions about consolidating the 2, and also where the government tried to stay one of the arbitrations, said that by these multiple arbitrations, India would have to eventually might need to pay up double, but that was not the case. Of course, the investor had chosen 2 different treaties and 2 separate arbitrations to be able to have benefit of the different wordings of the treaties that are available under the UK and of course the Netherlands treaty. So there are different reasons why investors file multiple proceedings in respect of the same facts. You could also have second situation scenarios similar to Vedanta Kane, where these are 2 unrelated companies, but the conduct has been the same. So assuming Vodafone, Kane, Vedanta, there are of course different tribunals that are sitting to determine on a similar conduct, from India's perspective, and you could have had different awards coming out, and giving different judgment, different decisions in respect of what India's conduct is. Of course, we do have to some degree publicly available information, but assuming we didn't, on purely basis the assumption. You had maybe Kane deciding against India, Vedanta deciding in favor of India, you had Vodafone deciding against it. So you could end up in a case where on similar facts, there are multiple different awards and decisions. So now when a fourth investor, a fourth case had to be filed, and you do look at like what is to be followed, what is to be expected out of, after the new arbitrations, it will leave you clueless. It will also lead to, because of the uncertainty, in the system, this inconsistency, that may pervade over, and which is a bit of a concern. And I think to some degree why there have also been debates about transparency. Of course, you do have ICSID awards that are publicly available, but a lot of these arbitrations under the UNCITRAL, which are ad hoc, you do not have those awards which are publicly available. So you're not even able to weigh in beforehand whether you do have a legitimate claim or not, which would become better if there were more consistent approach that the tribunals took. In fact, interestingly, if I may bring to your attention that how inconsistent is also the expectation, of the different arbitrators in terms of whether or not you should have consistent decisions. So we've had in different cases different observations being made in Saipem versus Bangladesh. The tribunal had specifically referred to that it's actually the duty of the arbitral tribunal to try and have as much consistency as possible, so that you're able to meet the requirement of legitimate expectation of community of states and investors towards certainty of the rule of law. Yeah. So to be able to provide that sort of degree of certainty of rule of law, it is actually upon the tribunals to be able to streamline and provide as much consistency as possible. To the other end, in Burlington versus Ecuador, while Professor Bridget Stern said that the arbitrators have a duty to decide each case on its own merits, independently of any apparent judicial trend. So her view was actually to the contrary. She said you don't have to be really looking at what's happening everywhere else and looking at the jurisprudential trend, but you decide each case on its own merit. So there are arguments both sides. So in fact, in the same case, in opposition, Professor Gabrielle Kaufman-Kohler, she commented and she said that arbitrators have a contrary duty, to instead to adopt solutions established in a series of consistent cases, of course, absent compelling contrary grounds, so that you can contribute to the harmonious development of investment law, and thereby, like I said, the central reason being that you're able to meet the legitimate expectation of the states and the investors, so that there is some degree of certainty of the rule of law. So there are different views about what do you even want out of the system. So while some arbitrators, some very well-known arbitrators, feel that there is a need to be able to, as much as possible, you're able to give consistent decisions. There are also the other set of arbitrators who feel that they're under no such obligation, and how they must independently apply their mind and understanding to each case without being affected at all. So the inconsistency begins from the expectation of consistency itself. So we do have a large task ahead of us to expect how do we in some way minimize this sort of inconsistency in investment treaty arbitration, that we see. Yeah. So when you go back and read judgment, decisions over decisions, and how each one of them be decided differently, how do you streamline the jurisprudence in investment treaties? So, and again, what are the ways in which you can address? And I was thinking over it while reading and preparing for today's lecture. I was thinking that how it can actually start from the very genesis of the investment treaty arbitration being the investment treaty itself is the drafting of the treaty. And like we in commercial arbitrations, we often emphasize to the corporates and everyone that so important is your arbitration agreement. It is so important how you draft these arbitration agreements. Similarly, it is so important how the treaties are drafted, to leave no ambiguity, to be as specific as if possible, to be absolutely clear and concise in the wordings that are used in the treaty. And that sort of minimized to a great extent, when those treaty obligations are being interpreted by different arbitrators. So really that foresight at the time of drafting of the treaties. So I think in India's standpoint, right now is really the most important phase for India if you look at the development of investment treaty jurisprudence in the future, because now they're looking at renegotiating the treaties. Of course, we've terminated majority of the treaties, but now when the renegotiation is taking place, how is the drafting of each of these obligations done? When you talk about the basic fair and equitable treatment, what does it not include? Sometimes exclusions are also a way to be able to define the ambit of an obligation itself. So to identify that as well in the drafting of the treaty. So to have absolutely clear treaty drafting by the states, when the negotiations are taking place. So if the more clear a treaty is, the less likely it is going to lead to a disputed treaty interpretation. And sometimes if you look at, like right now, the lessons from the interpretations of early treaties will become a ground to be incorporated in the newer treaties. So substantially, you do understand the import of what had not been done right in the past to be able to correct that when you are undertaking steps in the future. Yeah. Of course, at some level, a balance needs to be struck between something which is too broad to making it too precise. So you don't also want to have too detailed drafting, and which can limit the inherent flexibility of certain concepts. So one has to be very careful when you're drafting. So while you also leave some sort of room for interpretation in treaty language, so that it can adapt itself to new situations. Right? So you don't want the treaty to fall flat when the situation actually occurs, for it not to include what had been intended for it to be covered within the treaty. So a clear treaty drafting is, of course, one way in which we can bring some sort of consistency in investment treaty arbitration. Then, of course, I did mention about use of exceptions and also reservations. While this approach has its own shortcomings, but if on a balance, if carefully drafted to a great extent, can also overcome these sort of shortcomings. Another important element of when you are arguing a case in investment arbitration and you're looking at the import of a legal standard is the trivo proprietор. And I remember when we were working on a case, that how much effort had to be made to obtain that trivo proprietor, which is essentially the material before the treaty had been signed, all negotiations that undertook between the states at the time of signing of the treaty. So that is also a very important tool to understand what the treaty was meant for, what each of the standards were meant to be interpreted. For example, like a common issue of whether or not tax measures are included, in a treaty regime. You do look at the trivo proprietor to see, whether any objection was raised by the states at that time. Was it specifically considered, to be included, even when the language did not specifically say it in the final wordings of the treaty. So these are, of course, some of the important tools Another important tool, which will become exceedingly important, is when you can have a non-disputing states participation in arbitration. You know, what we also call, you can have an amicus in an investment treaty arbitration. So you can have a third party which can come and give submissions in the case, on the interpretation of the treaty, so that there is more consistent approach in terms of how the treaties is interpreted. Another important tool for consistency is what we call joint interpretive statements by states. In fact, when the treaties were being negotiated, renegotiated, India did issue some joint interpretive statements on the previous bilateral investment treaties. So this is also to sort of clear the cloud of where you know there is going to be a potential issue in terms of the interpretation. So how do you allow the tribunal to take a more consistent approach, is to be able to feed the tribunal with the correct information of what the states intended it to be. Now that can come by means of, like I said, it can come by means of joint interpretative statements by the states. It can come by way of means of where the amicus is appointed in a case. It can come by way of means where a third party submissions are allowed in a case. So, also, at some level, in terms of the procedural mechanism of how consistency can be brought in, is how you tackle parallel proceedings. And of course, the classic case of when you look at and you research and study about parallel proceedings, is the well-known case of the CME and the Lauder cases, which involve parallel proceedings brought by a single investor against the same state, based upon the same set of facts under two different investment treaties. In fact, the two arbitral tribunals in both cases reached opposite conclusions, where one found that the actions of the government entity at issue actually caused the destruction of the investment and awarded damages. The other one actually gave a decision to the contrary. So we've had in the past of exactly identical facts being decided differently by two states. So the answer to this, is again, how do we deal with these sort of parallel proceedings? How do you overcome, an issue like that? One approach could also be is to bring, if you can, stay the proceedings. But again, the arbitral tribunals have taken different approaches in the case. In fact, in Kane, given that Vedanta Kane were dealing with similar facts, and the transaction was the same in question, but the stay was not granted. But one will have to look at the facts and circumstances of each case to know whether or not it calls for its stay. What are the rights that are being protected against each of the treaties, each of the arbitrations. Another way in which you can, and very popular stream that you see in commercial arbitration, is the consolidation of the proceedings. Yeah. So you do bring in the parallel proceedings under the same ground, and consolidate the two, which also to a great degree address the problem of cost. Because if you're going to run two parallel arbitrations arising out of similar facts, but if they're consolidated together, it will also save the parties a significant amount of cost and overcome the fear of having inconsistent decisions in a case. So these are some of the ways in which you can deal with, or let me say, these are the potential mitigators of of what causes inconsistency in investment treaty arbitrations. Now, moving on to the next issue, if we look at, is really the efficiency in investment treaty arbitrations, and without getting into theory of duration and cost of how you can make the procedure more efficient. The examples, or let's say India's case study, speaks for itself. If you look at the timeline of when the cases were filed, what the implication of those cases been on state, how long did it take for those cases to have been decided. We do at some level get a snapshot of the issue that arise, in this area. Um, uh, Simply speaking, I remember, Vodafone, the decision of the Supreme Court came in 2012. It was in about 2014 when the arbitration, was conceptualized and was initiated, and it's not been, and it took a substantive long time for the arbitration to have been decided. And if you look at the question of efficiency, it arose right at the start when you were appointing arbitrators. It took a long time for the tribunal to be constituted in that case. There was an arbitrator who withdrew, and then somebody else had to be appointed, and there were some challenges to the arbitrator. So from 2014 to about 6 years, that it has taken 6 to 7 years to finally have an award. Versus when we look at commercial arbitrations, we look at the timeline of about 12 months, for a case to be decided in an institutional arbitration. And in some cases where there have been complications with the conduct of the parties, a little bit of more extended timeline. But from 12 months to about 7 years, there is a significant difference. And the stakes get stuck, the monies get blocked, for that much period of time. So this, I believe, truly not just from the investor standpoint, but from the state standpoint even more, because it's the exchequer's money that is involved. We all pay taxes, and it's that money that the state utilizes to defend itself in a case, or to pay the costs that may be imposed against it, when the case is decided, or the damages that it might have had to pay. The interest, if you look at, I think, more from the sovereign standpoint, that it's important to be able to deal and tackle the inefficiencies that are inherent in investment arbitration, more when there is no structure, in terms of how these are conducted, how the appointment of arbitrator is taking place. Is there some timeline, within which the parties must conduct itself and respond, in terms of the proceedings itself? That's a very important factor. Is there some way the cost can be controlled? Of course, when we do speak to people in the field, who are working in investment treaty arbitrations, we do recognize that investment treaty arbitrations involve very, very high stakes as compared to as compared to your commercial arbitrations, because the states are involved. So how do you deal with these sort of inefficiencies which arise from the duration, because the time that it takes to conclude an investment treaty arbitration, the implication, and very interestingly, like I said, we were at some point discussing about, what will come out of COVID-19 measures in terms of investment treaty arbitration. And personally, I'm of the view that a lot will depend on how the first case gets decided. While of course there is no stare decisis in arbitration, but to some degree, even for the investors to weigh in where their position is, and even for the states to understand what position should they take. The first decision will be a very important indicator, to that, and in certain way will give direction to the disputes that may follow thereafter. So assuming a state took a measure, which of course affected not one investor, but multiple investors, and one investor filed a case against the state, which the state lost. And therefrom arose a slew of cases in respect of the same action of the state. So you end up having multiple claims by multiple investors. So the state's liability will multiply to that number, which means the cost that the state would have to pay will also multiply. The resources that it will employ in a particular case will also multiply to a great degree. So the numbers are very, very high in an investment treaty arbitration. So the states need to take cognizance of this and not treat the efficiency aspect of an investment arbitration lightly. Um, so that again is an important point when we look at the efficiency in investment treaty arbitrations. There are of course different parallels or different ways in which we can draw from how the commercial arbitrations have been able to achieve some degree of efficiency, in their own conduct. There are mechanisms that are available in investment treaty, in commercial arbitrations that can also be borrowed in. And to some degree, some institutions have provided specific rules for investment treaty arbitrations. SIAC IA rules is one such example. And of course, there are other institutions also working towards and have released rules, particularly for investment arbitrations, and provisions such as, you can have a mechanism for early dismissal. So where you have an unwarranted claim against a state, and if the state can get a dismissal of that unwarranted or something which is manifestly without merit, manifestly without jurisdiction, if you can get that dismissed right at the beginning, then you don't have to run the cost of of undergoing the entire arbitration to the end. So the states will have to look at how to find ways to tie in these mechanisms in investment treaty arbitrations that it's taking place. Similar is you do have, of course, ways of expediting your procedures. If you have a smaller claim, can you in certain way, what you have expedited procedures, can you have a similar mechanism being followed in investment treaty arbitration? So those can also be looked at. You can look at ways to minimize challenges to the constitution of the tribunal. So where there is a significant disclosure of the arbitrator, so it does minimize the grounds on which you would challenge the independence or any potential bias of the arbitrator. So when you're selecting the arbitral tribunal, within how much time frame do you conclude you have the tribunal up and running? And these are usually provided under different arbitration rules, and which needs to be taken very seriously, in investment treaty arbitration. So you look at the number of arbitrators, you look at the timeline for appointment these arbitrators, you look at the grounds for challenging these arbitrators. So you're not unnecessarily just raising a challenge to just cause delay in the proceedings. Another concern in terms of efficiency, which often gets raised in investment treaty arbitrations, is lack of availability of arbitrators. Because it is, like I said, it's a very nuanced field of law. The contours of investment treaty arbitration, because it's not only dealing with the domestic law, it is looking at the international responsibility of the states, it's looking at the customary international law, and like I mentioned in the beginning, how the applicable laws are just so many. So you need arbitrators who have that sort of understanding of the field. So there is, if an interesting study would be to, if you go back and see different awards in investment treaty arbitrations, how you will have very similar names in different awards. Yeah. So the pool of the arbitrators for investment treaty arbitrations. So there have been some concerns that there is a limited pool that is playing around, and sometimes it's the arbitrator which has acted as a counsel in another case, and an arbitrator which had been selected. What happens if the state continues to select the same arbitrator in multiple cases? And how do you position yourself, when you're appointing, and how do you choose the right arbitrator in your case without thinking that I am appointing an arbitrator to really advance my cause? And that's really not the purpose for which an arbitrator is appointed. You need to be able to have an arbitrator who will have weight when it sits as part of the tribunal, who will influence the tribunal to do the right thing. Yeah. And these considerations when you're appointing the arbitrator. So this appointment of arbitrator process is itself a very, very important tool, to overcome the inefficiencies that are identified in the system of investment treaty arbitrations. And of course, a way to be able to dismiss meritless claims or issues, not to have unnecessary filings against the state, and not to have unnecessary filing of objections, and such things that have been raised during the process of the arbitration. So the conduct needs to be managed, in the arbitration proceeding. And how do you manage, this conduct is something the states need to take notice of. Of course, like I said, the institutions have rules that do provide, for such mechanism to play. Then also is important, is to be able to have some procedure for claim settlement, and not necessarily to run the arbitration for the sake of running the arbitration. In fact, I think states need to pay greater attention to means such as negotiations and mediations to try and settle the dispute as early as it's possible, and to take this process very seriously. So if you look at the language and the wording of the treaty, most treaties in terms of resolution of the dispute provide for before the arbitration is to commence, for some period, like what is called as the cooling off period, where the investor and the state can try and amicably settle the dispute or resolve the dispute. I think that process, the pre-arbitration process, needs to be taken very, very seriously, not just by the investor, but by the states, particularly, so that you understand the consequences of if you do not undergo a settlement. So if a dispute can be settled at the earliest stage, it will of course cut down the costs substantively. It will save the state the time and the sort of procedural difficulties that it will have to go through if it have to run the arbitration at the end. To a great degree, I think it's important to educate the disputants about these mechanisms within the ISTS. And I think it's a good step, if you compare to lectures and webinars and sessions that were taking place about 10 to 12 years ago, where you had conferences. I do not recall any major conference or any major lecture on investment treaty arbitration at that time. But now we are all discussing it very seriously. I think students are very keen to know and understand the parameters and what all not sort of gets played within the system of investment treaty arbitration. So the more we understand, and know all of this, and we will be able to come out with better solutions. We will be able to come out with better responses to the situations that will arise in the course of these investment treaty arbitrations. And I hope there are more people who do doctorate in the fields of investment treaty arbitration, so that India, as a whole, how they're responding in terms of its own policy, it takes very well-informed decisions, in its own approach of these investment treaty arbitrations. Because of course, when you look at how India's response has been to investment treaties, while some section of people like to use the word backlash, I think at some point we also need to understand that how India stands in a very sensitive position. We are in a way trying to bring FDI, to promote FDI, because we do understand the importance of foreign investors in the country. At the same time, there is a persistent need, for the sovereign state to be able to take the actions that it considers fit in the given situations and scenarios. without having the fear of being challenged or being caught up in multiple arbitrations under different treaties. So to be able to balance these rights, and where it just doesn't simply forego the entire regime at itself. I don't know. I mean, we will have to wait and see. Are we in a position to forego the regime completely? Or we do need to, which has not been the response. We have seen India trying to renegotiate treaties, but like I said, that in this response, how does India sort of carefully weigh in both rights and obligation, the rights of the investors and the obligations of the state itself, is going to be very, very important and interesting for us to see in the way the response is. Another important point, if we talk about the efficiencies, is the time that is taken to deliver an award. Of course, we all look for a well drafted award, and it's the council, the arbitrators, and of course arbitral institutions wherever they're involved, who can contribute to an efficient drafting and delivery of the report. And at this stage itself, to have, while counsel are presenting their cases, when they're presenting their pleadings, etc., to be mindful of this, that how they are contributors to this whole process of an award, which award, of course, will become, which is the fruit of the proceeding itself, and where it will determine which side the parties stand. So it has to be very, very, I think, carefully deliberated upon by each of the stakeholders of the drafting of the award. It's not only the tribunal's responsibility to produce well-drafted award. It is equally the responsibility of the council who are involved, to be able to assist the arbitrators in establishing the facts, the correct facts. In fact, in some cases, it is suggested that parties confer and draft together a timeline of undisputed factual events for tribunal's benefit. So when you do have, this concrete list of undisputed factual events, you are not going to and fro, you're not wasting times on things which does not require attention, where the parties have come together and said, okay, these are undisputed facts in our case, this is the undisputed position of law and damages, and therefore the arbitrator can proceed on that basis. So imagine if we're able to arrive that sort of understanding, how much it will cut in terms of the cost and time that is involved, and the deliberation in the process of drafting of the award itself. Again, when we talk about the process of efficiency, you do look at the submissions that are made, and I can, by way of example, again refer to the cases that I were a part of in investment treaty arbitrations, and I can't tell you the volumes and volumes that ran into each of the case, the number of submissions, the lengthy submissions, the exhibits, the expert reports, the witness statements, all of that. Like, it's hugely voluminous. Like the whole pleadings, the whole evidentiary material and the cross-referencing. And so it's not easy for just a few number of people to be able to sort of maneuver around these pleadings, because it was so lengthy and so heavy. But in some way, to be able to find a way that these can be streamlined. I think fortunately with the pandemic, we have seen a lot of online filings and use of technology a lot. It's easy to switch between the pages and the cross-referencing, etc. But this submissions and exhibits and all of these pleadings part is also a very, very important part of bringing efficiency in investment arbitrations, and these should not be overlooked. And not be taken for granted, and pleadings should not be made just for the sake of being pleaded, and not to think that when a fair and equitable treatment violation is being alleged against a state, one has to state every single law that exists for FET. You have to be able to clear wheat from the chaff and be able to sort of come up with concise arguments on and the case laws that are relevant on point. Again, the number of post-hearing memorials that get filed should be reduced, and in fact, they should be targeted to answer specific questions from the tribunal. And one important part that I remember from the proceedings was really the document production. And it used to be hugely tiresome to go through this whole process of document production, because the other side would end up asking for every single document that can possibly exist within the purview of the case. So we have more specific requests, even when the stage of document production takes place, and these should be carried out very, very responsibly. I don't hear many people talk about how important it is to carry out document production responsibility, and how it has such a huge impact, in terms of the efficiency of the proceedings. Because when you ask for every single document under the sun, the task of being able to produce those and then to review them, in terms of what is going to be relevant, not relevant, the time spent on the case, of course, gets multiplied. So these are, certain important ways in which you can police around, and of course, the arbitrator has a very important role in achieving, some of the efficiencies that we are talking about in investment arbitration. In, how does an arbitrator sort of police these lengthy submissions, and how do you use procedural orders to sort of, which can be sort of crafted very well to be able to deal with these lengthy submissions, to sort of, in a way, handle both parties as well. And very important that these procedural orders are able to establish the categories of evidence documents, the legal authorities, witness statements, and expert reports, which are admissible in the case. So, like, I think the onus is a lot, of course, on the arbitrator. Because as the master of the proceedings, it does have a huge responsibility on itself, to respond in a way, that is going to be most efficient for the process. And I think you need a taskmaster over the tribunal, which in some way the institutions do. And that job of ensuring that the arbitrators do, what they're supposed to do, and do it well, is also important. And that's where the application of the arbitral rules come into place, and the importance of an institution in being able to administer an arbitration come into place. So not to oversee that it's only in commercial arbitrations, that we are all advocating the use of institutional arbitration, but it's also very, very important, particularly from India, where, we're not a signatory to ICSID. And we are running ad hoc arbitrations, ad hoc investment treaty arbitrations, to be able to sort of deal with all of these situations that I have just identified. Moving on to another issue, which is very, very important and hugely contested. And I still hear, I think ever since that I have known of arbitrations, I've been hearing people discuss about it. And it is as much contemporary as anything can be, is the issue of transparency in international investment arbitration. We've all been discussing how we need to have, there have been a lot of debates, at least in the commercial arbitration front, where people have talked about, the need for more disclosure of awards, the need for, some sort of public access to the pleadings that are involved in an award. There is, of course, a great degree of merit that is there in not, not allowing the material relating to an arbitration to go public, because of the confidentiality, because of the sensitivity of the information that are contained, and because of the inherent promise in the arbitration itself that it is going to be confidential, that it will allow for companies, not to disclose everything out in the public, and not to, in fact, let their dirty little be displayed out, when the parties are fighting against itself. But when we look at investment arbitration, I think the balance sort of swings slightly differently, which again, to the point of, like I said, one, for the state, because it is responsible to its public for the way it is using their money. It is responsible, the state has an added responsibility in terms of how it is engaging itself in different dispute resolutions. So there have been, I think, there have been long critics of investment arbitrations where people have condemned that there is a lack of transparency at all stages of the dispute. And there has been a great demand, and I think there's a great lobby working towards it to increase public access, the hearings, the materials and awards that are produced in arbitrations. There have been greater emphasis on third-party participation through amicus briefs, disclosure of third-party funding. So these have been really centering around. In fact, if you look at the recent changes in treaty practice and arbitration, they have also introduced within their mechanism a certain degree of transparency. You do have certain treaties that have been negotiating, which does provide for provisions for disclosure of third-party funding, which does talk about disclosure of certain information relating to the case itself. In fact, under the SIAC-IA rules itself, there has been some effort that has been made to balance confidentiality and the need for transparency, where SIAC is able to disclose certain information relating to the dispute of an investment treaty arbitration. So, if we do look at how the newer treaties that are being drafted, states are cognizant, and in fact, when I go back to some of the cases earlier, I remember in one of the cases when the Mauritius Convention had just been concluded on transparency, and how the state had filed an application, even though it had not ratified the convention, and the state argued that we would like the transparency convention to apply, and we would like to release these information regarding the matter. And the tribunal had actually not allowed it in that case because the rules were not applicable. So of course, there is a lot of to and fro where states, because of the obligation, or do consider it important that the information relating to the case should be made public. And on the other hand, the investors, which do want to keep things, because the cases involve confidential matters, they would sort of lobby against making information public. Yeah. So transparency is of course not just one tier approach. It has also different dimensions. It also has the dimension relating to the appointment of arbitrators. In fact, people would want to know that it should be made much more transparent in terms of how the appointments are being made. Where all has the arbitrator been engaged before? Has the arbitrator ever acted as a counsel for the other party, or in similar cases for other parties? So that whole decision-making process is much more transparent. There is some degree of attention to, even when there is institutional decision-making, how they would like the process to be more transparent, to understand how the appointment has been made. And greater debate, and this is not an issue on the legitimacy of third-party funding, but really is the existence of third-party funding how the parties want that, to be able to know if there is a third party funding involved in a case or not. In a commercial arbitration, unless the rules provide for, there is no obligation on a party to disclose a third party funding. In an investment treaty arbitration, there is a lot of emphasis that there must be an obligation, and particularly the states have expressed the view that they would like to know, whether or not there is third party funding, and that in some way will also sort of allow that there has to be a security for cost, where there is a third party funder who's involved in the case. Again, the aspect of making the arbitral awards public, whether or not you're able to broadcast hearings and the document productions, while there is a need, or like I said, an emphasis on making these things public, there is also a risk. But if you do make the document production process public, or if you do broadcast the hearings and publicize every award, how there is a likelihood of increase in inefficiency in the process, because like I said, too many people being involved, too many eyes scrutinizing the process may also lead to inefficiencies, of where more third parties would want to be involved, which will entail that they would need to be heard, which can delay the entire process, and so many unnecessary filings may come about, unnecessary challenge that may be brought about. So the need for being transparent needs to be carefully deliberated and balanced, with also maintaining some degree of confidentiality in a case. But like I said, the exit awards are available online for people to read. But really the issue for us from India's standpoint, being a non-signatory to exit, is for the other awards which are sort of undertaking in ad hoc proceedings. So these are some of the challenges that I identified in terms of the issues which are there with the proceedings. There has been some way in understanding how do you respond to those. And I would urge people to closely follow, those who are interested in investment treaty arbitration, to closely follow the UNCITRAL Working Group 3's reports that have been coming. So of course, this commission was set up. The working group was set up by the commission because there's great discussions about how there is now a desperate need to reform the investor-state arbitrations, the ISDS mechanism, and the first task that the working group had was to identify whether or not there is a need. So that task has been done, and they have unanimously agreed that there is a need for a reform in the system. There are, of course, different ways in which parties are looking at whether or not, of course, from the Europe standpoint, you need to have an investment court. Is that an answer for consistency? Is that an answer for transparency? And you have debates both sides. You do have people debating and saying that that would really take away a very important element of appointment of arbitrators. It will take away the genesis of why arbitration was introduced as the way to resolve investor-state disputes. And so if you do introduce the sole court mechanisms, parties will have no right, to look at, their decision makers, and which is an important element of, of arbitration itself. So do you do away with the process of arbitration, when you look at resolving the disputes? What would happen, to the interest of the investors, and then so you do have debates on both ends, even in the reforms that are being discussed, and the suggestions that are being made, including, in terms of the transparency of whether or not to publicize more and to have more access to the workings of an investment arbitration. So we will have to wait and watch how these transpire, and see how much of these recommendations sort of get integrated within the system itself. Unfortunately, if I can use one word for the reforms in investment arbitration, it is very, very slow. So we're still at the stage of from 2017, when the working group 3 was tasked to look into the reforms in investment treaty arbitration. We are in 2021. We still do not have concrete points for reform. And even when assuming once the pandemic is over, and we do have concrete points of reform for them to be integrated into the treaties. And of course there are current treaties in place, and those that have been terminated. Even with the terminated, there is still a sunset clause which allow for the treaties to play in for some more time. And then once the treaties have been introduced, the investments that would be made into the newer treaties, and then for the dispute to arise. So I think we're looking at the reform process to be extremely slow, as we compare it to, I think, commercial arbitration, where the rules are revised, and you do see changes, in the rules being integrated, and agreements being drafted on the basis of the newer rules. So of course the reform process is slow, but that does not mean that we don't discuss the issues. That does not mean we do not identify where the standing is, and what the approach is going to be. And of course, we will continue to deliberate on the newer treaties that are being drafted, including the India-Brazil treaty, where there have been, I think, some degree of criticism, because it has taken away, in a way, the investor-state arbitration itself. It has allowed for state-to-state mechanism, for resolving the disputes. Will they provide the effective mean for resolving the grievances of the state, of the investor? And I think while we're bringing about the reform and the changes, and we're discussing about all of these, including the disclosure of third-party funding, and disclosure of the process of appointment of arbitrator, the greater transparency in that, how the challenges are being made, etc. I think we need to not forget the most fundamentals of the investment treaty arbitrations. Why is it in the first place arbitration was introduced as a means for an investor to resolve its case, its dispute against the state? Why was it not, that in addition to what was already in place, that an investor would go to the sovereign state itself, that this whole mechanism of court existed. So I think at some level, to be careful about this, to be careful about the fundamentals of this entire process, the genesis of investment treaty arbitration itself. And I think it's only on the basis of this that we can truly look at the developments in the future, that we can truly look at what changes and how do you shape the process better. I think these are some of the points, and I'm happy to discuss more based on the questions that come along. So Rajyoti, any questions so far? Or
Hi, Sweta. So I am receiving the question on WhatsApp, so I asked them to write it in the chat.
Okay.
Actually, we do have quite a few questions.
Okay.
So the first one is by me,
Yeah.
and I'm asking it based on some observations you made. So
Yeah.
basically, what I understand from your presentation is that your recommendation is to make it similar to international commercial arbitration, right? The systems and processes that we have in ICA, you bring those things in the investment arbitration as well. So I'm just picking your brains here. I mean, let's not, I mean, let's just take it one step further. Like now like the investment arbitration, this whole idea came up at a time when the world was, broken up into small, non-reacting countries. Like there was no synergy between the courts and the processes of different countries, right? So now you have this international commercial arbitration, which is matured. Now you have the international commercial courts. Now you have the Hague Choice of Court agreement. So do you really need to have this process at all? Because you see, ICSID or any centralized system will always take time to change, time to adapt.
Yeah.
In international commercial arbitration, you can always have a SIAC rule and a LCIA rule and a ICC rule, and they will be competitively changing themselves. But you can never have it here. So is it something which is now, I mean, really, is there any need for relevance for it, or should we just lose it in next, say, 50 years?
Are you suggesting to not have arbitration at all for investment?
No, I am saying, do we need investment arbitration as a separate category, or the other evolving categories would one day subsume it?
Yeah, so that's a very interesting question. And also, I think so when I first joined SIAC, and having had a bit of experience in investment arbitration, the first task, for me was to really look at the rules that SIAC had. So we, of course, had the commercial rules, the 2016 rules that are prevalent, and there were these investment arbitration rules. And I looked at both the rules and I looked at the similarity between the two. And I asked myself, I said, why was there a need for investment arbitration rules? Why is it that the commercial rules, could simply be brought in a treaty and said these are the rules that will apply? But the answer to this is it can't be, and it would not be efficient to do so, because even though there are things that can be borrowed from commercial arbitration in terms of rules and certain procedures, like I mentioned, and certain mechanisms that must be adopted to make the system more efficient, there's still peculiarities in investment arbitration, and which largely arise out of the involvement of the sovereign state. You can't impose the same timelines that you can on two private parties or two commercial parties on the sovereign state. It would not be feasible, while there has to be a structure, but that structure needs to be tweaked. We can't have amicus in or third party submissions in commercial arbitration, right? Unless someone is joined as a party. There is going to be a greater need of confidentiality in a commercial arbitration versus an investment arbitration, which, because of the public law element being involved, will have some degree of need to be made public. Whether and if not within the system itself, in India you will have PILs being filed asking for information relating to an arbitration that India is fighting. So India will have, if the Supreme Court is going to order against India and say, no, you are required to file, it will have an obligation, that it will have to sort of exempt itself and ask the tribunal that it has to release the information. So there are the obligations of the sovereign state, the nature of the dispute itself warrants some sort of modification. And that is why, you do have institutions now who are bringing in more specialized investment arbitration rules, particularly when you can't be a party to ICSID. In fact, people are also looking at, reforms within the ICSID mechanism itself. It has its own two-pronged test for investment. So there are, you're already testing the waters of what exists. But going forward, what can be a better way when you can marry from best of the both worlds? So you borrow in from commercial without replicating, because the realities are not the same. The realities of an investment arbitration, let's be realistic. While you can ask the tribunal to push the state to produce the documents, it is not going to be easy. there is a different kind of bureaucracy also that exists, when you're dealing with it. Different sanctions that the state needs to take when it's responding to an investment treaty, because it's not one-off case. Like I said, if it loses itself in its conduct against one investor, likelihood of similar cases arising from it is going to be much more. So when the telecom licenses were cancelled, it was not one case. You saw a series of arbitrations against India. So how India would respond against one investor had to be very carefully deliberated. So India would have to keep going back to its own boardroom with the ministries, etc., that how they're going to respond. Versus to commercial parties, the decisions are taken much faster. Yeah, so that's one big factor. Like I said, for amicus is another important. For the state to be able to come and give submissions even when it's not involved is again an important part of how you're interpreting the treaty, right? All that is not required in a commercial arbitration. So while I said, and I did mention a lot of the aspects from the commercial arbitration, this is with the caveat that you need to be able to tweak the rules to the realities of investment arbitration to have an effective response to the issues that we are identifying and raising.
Okay. So the second, we have a series of student questions. They have a common vanishing point. But let me first ask you the question by Muhammad Aram. So he's asking me why not have an umbrella clause in each of them and just dispense with, like you have a two-step process, right? You have the first arbitration, you don't get whatever you want and you go for step two. I just don't universalize the system and on that make it easier. On that make investment arbitration faster.
I'm sorry, I haven't really understood the question. He's saying to have
So,
an umbrella clause.
To universalize the system, you said that there are multiple proceedings because of structuring, but also because of multi-step proceedings, right? You can like exhaust your remedies first, and then you go for investment. So instead, just have an umbrella clause everywhere, and I mean, won't that be an easier option out? I mean, to what extent I understood his question here.
Okay, I may just tweak the question a little bit to I've understood it correctly. So what is the implication of an umbrella clause? What does it really provide for? So when an investor invests in a state, particularly in maybe situations such like concessions, so you have a contract with the government itself, right? So there is already a treaty by the state from where the investor has come, with, of course, the state where it's investing. There is also an agreement that it is entered into with the state, right? So the question is, when the dispute arises, when the state has done something that has affected the investor's right, for example, under a concession, maybe there is a concession to build an airport by a foreign investor. State has done something because of which the concession cannot take place. Foreign investor is not able to complete the completion of building the airport. What remedy does it have? Yeah, I think the question is suggesting to have one mechanism where you can address
just have one switch.
Yeah, so so umbrella clause is that you can deal with it. So and then there is, of course, a fair amount of jurisprudence is which route do you choose, right? If the treaty allows you to raise disputes even under another contract, you will do so. The treaty may not allow you to do so. So it's really the language of the treaty, and the language of the treaty may be such that if you do have an agreement in place with the state outside of the treaty, if the investor has an agreement with the state, then you can only enforce your right under that agreement and not under the treaty. Yeah. So to be able to simply answer the question, you will have to look at the language of the treaty. In some cases where there is an umbrella clause, which means it can bring it under its umbrella, even something for which there is a separate agreement in place, right? And for that, you will challenge that it's the sovereign conduct that has led to my right being affected. In those cases, you will bring it all under the treaty and not under separate disputes. So it's again a decision that the state would have to take when it's negotiating its treaties, that I want to be able to provide to the investor one single mechanism to raise its grievance against me, and not to have one arbitration against the agreement under the agreement under which the investment is being made, or have domestic proceedings, but to be purely raised under the investment arbitration. So it's really the language of the treaties that would have to play out. It will depend on the policy of the state when it's negotiating and finalizing the treaty. But it's an important point. I think, like I said, a good drafting of the treaty has an important role in sort of dealing with a lot of these issues that we've talked about. I think Subhrajyoti has dropped. Are you still there, Subhrajyoti? If there are more questions, maybe you can put it up on the chat. I believe his connection, he's just dropped out. Niharika, are you overtaking? Or would you be? Yeah.
Yes, so there are no questions as of now on the chat. I will just be asking Professor Suvrajyoti if there are any more questions.
Okay. I believe he had some on the WhatsApp, which he wanted to ask and raise.
Yeah, if we could just pause for 2 minutes, I think, while he shares the questions with me, or he reconnects.
Anything that you wanted to ask, Niharika? I mean, I kept the time aside so that, if anyone else also wants to sort of come on board and ask.
No, ma'am, I actually found your discussion really insightful on investment arbitrations, and what you said about the BITs and their role in India. And I think it was a great lecture. And Professor Suvrajyoti will also just be joining in a minute. He's just mentioned that to me. Ma'am, what I wanted to also ask you is, why is India a particular target for such investment treaty arbitrations?
That's an interesting question. I think I mean, rather than looking at India being a target for investment treaty arbitration, I think it's easier to position India as as an important economy, because India, of course, is a big country and has a great amount of foreign investment flowing in. So the involvement of foreign investors is very high in India. And of course we do, because the jurisdiction is bigger. The states are also more fluid in terms of the actions that they are taking to respond to different situations that are arising in the country, which have had its own implications. And which is precisely the reason why you do see investors, sort of taking this route of not attacking, but maybe addressing the disputes that have arisen in the course of their own investment. Yeah. And in fact, if you you do look at the history of cases in investment arbitration, it has usually been against states which is also more evolving in its own policies. And I think in last few years, we of course have had a more stable government, but we did see a change in the government, which meant change in policies much more. And even now, there is some degree of experiment with the policies, the changes, to respond to different situations. So now how that impacts foreign investors' rights. We of course do have a lot of treaties in place also, one, of course, we talk about the termination of the treaties, but prior to that, there is a great degree of number of treaties that existed, and I think all of this has surfaced more so now than before after the white industries. I don't think the investors, really sort of weighed, where they stood in terms of what are the options they had against different conduct which affected their investment. But this became more prominent after the white industries case, when they realized that this is a route in existence. So like I said, how one case opens the way for the others. So the white industries, blaze the trail for the other investors in that sense. And that is the reason why, we did go on to see a lot of cases against India in the recent past. Subrajyoti just messaged asking for another question. I think somebody's asked if the principles of lis pendent and anti-suit work well in investment arbitrations. Like I said, that we did have and this is in public domain, the case of anti-arbitration injunction being sought, which is in the case of Vodafone. So of course it is in existence. The difference really lies how the courts would respond to such anti-arbitration injunctions being sought. And there is no blanket formula to apply it in a given case. You will have to see if the arbitration is not being misused against a state, where you do have parallel proceedings and an anti-arbitration injunction is being sought. So the principles would, of course, apply to a great extent, but you will have to look at the facts and circumstances of each case. You will have to look at the arbitration, on its own standing, and see that whether the circumstances exist for anti-arbitration injunction to be granted. I think, a step forward from this question has been the discussion about whether the sovereign states courts have the jurisdiction to grant you an anti-arbitration injunction, and which is really a function of, if I zoom out a little bit, you are aggrieved against a state, and under the international law, the state would include different machinery of the state, including the judiciary. Would you allow the state to rule against, to stand a judge where it is itself a party? And that's really the point of contest, and an issue that is being raised more internationally is where the domestic court is determining whether or not an anti-arbitration injunction should be granted against an investor where its own state is the party. So there are, on the optics standpoint, at least it doesn't look right. Yeah, I can't be ruling where I am myself a party. While of course we do trust the system for all its fairness and neutrality and all of that, but it's important to zoom out and look at from the international standpoint, and not at a level where you're only looking at whether or not judiciary is able to determine that there is an abuse of process, and there is a need to grant anti-arbitration injunction.
Okay, thank you, ma'am. I think I especially resonate with your view on, how it looks for the international community if a domestic court does give an anti-arbitration injunction where one is a party to it, and I completely agree with you on that. And so I think Professor Surajyoti is still not here, and but I would like to take the honor and give the vote of thanks and conclude the session. So I would really like to thank you, Ms. Shweta, for conducting this lecture and having this insightful conversation with us on investment arbitrations. I would also like to thank Mr. Professor Suvrajyoti Gupta for organizing this lecture. And also, I would like to thank all the participants for joining us today and the IT team for assisting us in this process. Thank you. With this, we've come to a conclusion on this SIAC lecture series. And we look forward to hosting you in the future as well, ma'am, if
Excuse
the
me,
opportunity presents itself.
ma'am. If we have to communicate directly to you, how can we do that?
Hi Shreyansh. I just saw your message on the chat. You can send me an email. My email ID is given on the SIAC's website. So you can send me your query, or if you wish to speak to me.
Yeah, ma'am. Sure, ma'am. Thanks, ma'am.
Yeah.
Thanks for the session, ma'am.
Thank you for attending. Thank you everyone for taking out the time on a Sunday evening. I think that's an extra effort for everyone, rather than with things being sort of relaxed in the city and everyone's going out. You've all sort of chosen to stay tuned in for the lecture. So thank you so much. Thank you, Jindal Global Law School, for this series. So Suvrajyoti just messaged to thank once again, which I thank him in return. And I believe his hotspot has given up. But I can have him in full spirit and sense him, being around. So thank you everyone. And I look forward to hope to interact with you all in future in person. So thank you. Have a lovely week ahead. Thank you, Niharika, for stepping in. Yes. So have a good week ahead, everyone. Thank you.
Thank you, ma'am.